Today we are interviewing Charles R. Dyer, who retired in 2005 from the position of Director of Libraries and Secretary to the Board, San Diego County Public Law Library. He had served in that role for about 18 years. Prior to that, Charlie, as Charles is more commonly called, was an academic law library director at the University of Missouri, Kansas City. Since his retirement, Charlie has remained active as a consultant to law libraries and court systems and as an independent researcher. Charlie, let's begin with a little personal history. Can you tell us about where you were raised and about your family, both when you were young and today?
I was raised the first 9 years in St. Anne, Missouri, outside of St. Louis. And then my family moved to San Antonio, and so I graduated from Thomas Jefferson High School in San Antonio, and then went to the University of Texas at Austin, where I did my undergraduate work. First, I was a major in both physics, thinking of being an astrophysicist, and also in the liberal arts honors program. But I dropped out of the honors program because it was grading on a curve, and the physics department was saying I needed to keep my GPA up really high. So I dropped out of that program, and then so my sophomore year I took electricity, magnetism, astronomy, differential equations, advanced calculus, and scientific German. And I realized about halfway through the semester that I didn't really like lab and didn't think that I was going to be able to be the theoretical physicist myself. So the second semester I just changed completely. I took a couple of philosophy classes, a psychology class, a sociology class, and continued my German. But the result from there was that I ended up being a philosophy major and graduating with a major in philosophy and a minor in mathematics, having earned all my mathematics hours prior to any of my philosophy hours. Then I went on to graduate school, went to Northwestern University. My concentration, the University of Texas had a very broad, large philosophy department with lots of different types of philosophy being discussed at the school there, and I became fond of phenomenology and existentialism. That would be continental phenomenology, similar to coming from the writings and the philosophers who were disciples of Edmund Husserl. So Northwestern had a significant number of professors who were big in that area as well. So I went to Northwestern University in Evanston and got through the master's program. Became very intrigued with interest in how, not just looking at the world through the phenomenological view, which is essentially trying to see how we humans would look at the world prior to having our concepts placed upon what we're looking at. So just how do you see the world in the raw, if you will, and how do we build up our knowledge out of that sort of circumstance. And I was very impressed with newer writers who are moving into the field, like T.E. Hansen and a couple of others, and so these were the ones who have this, you see them very plainly now, but they were very new at the time, like the picture of the old woman looking one way and you look at it another way, it looks like a young girl who's turned around. Those sorts of ways you can take the same photograph and see two different images out of it, because conceptually you lock onto one or the other, and your brain can't do them both at once. And so it was very interesting learning about that sort of stuff. And so I was very interested in philosophy of science. Became very interested in the writings of Thomas Kuhn, Structure of Scientific Revolutions. But I also became interested in philosophy of law, and then and very much so, and then I read a phenomenology of law written by a Dutch scholar, and he just didn't make sense to me. He wasn't wasn't true enough. I knew enough already about life and experience to know that he was far off base. Partly, I didn't realize what the difference was that the British and American legal system was so much dramatically different from civil law systems in Europe. I didn't know that at the time, but what I did feel was that I did remember fondly several professors I'd had who taught ethics and a couple of them had law degrees as well as PhDs in philosophy. So my thinking was, I will go to law school, get a law degree, and then go to another school and finish my PhD. And that's what I chose to do. So then I went back to the University of Texas to go to law school, in part because it was much more reasonably priced for me to do so, since law school didn't have nice teaching assistant scholarships and other such things as you would find in graduate programs. And while I was there, I got a work-study job in the law library. So that's where I first became knowledgeable at all about the law library. Working at the University of Texas Tarleton Law Library under the very well-known Roy Mirsky. And my immediate bosses were Terry Martin, Lance Dixon, and Frank Liu, all of whom are in the Hall of Fame, I guess, or pretty close to it anyway. So, so they had obviously a great wealth of mentorship going on right there and when I was at that age. And so as I looked at it also, the other thing I had was the lucky job as a second-year law student of going around to the various faculty offices and picking up their books to take them back to the library. So I got to know a lot of the professors much more closely than most of the students at the University of Texas did. It was a very large school and some of the professors were pretty distant. As a result of that, one of the things I really realized was that law professors are way more happy than philosophy professors. They get paid more, and if they don't like teaching, they have something else to do. So the law professors were self-chosen as people who really did like teaching and doing research and papers as part of their work. So I began then to think about becoming a law professor. And found, much to my surprise, that I also had an affinity for administrative responsibilities. By the time I was a third-year law student, I was already managing the other work-study students there at the law library and actually helping out with the hiring process there. So it was fairly natural for the librarians there to encourage me to think about going on to library school. So I graduated in 2.5 years from the University of Texas School of Law because I went both summers, and started library school in January of 1974, and then graduated in May of 1975. That whole time I was working there, I was working full-time, essentially as the evening reference librarian, although because I didn't have the master's in library science at that time, I was called senior research assistant because the rule at the University of Texas was that you could not be ranked as a librarian unless you had your MLS. And so at that point, I then began to look to see where I would go from there. But that was how I kind of completed my education, was walked right through it and sort of fell into law librarianship and thinking of academia and realizing if I were going to be in academia, law school would be something that seemed a lot nicer. And so I guess that kind of tells you my stuff on education.
Could you describe the specific positions that you've held during your career after you finished your work at Texas and then moved on?
In the summer of 1975, I interviewed with Eileen Searles, who is the law library director at St. Louis University. And she was off on a trip. She actually interviewed me at the AALL convention in Los Angeles that year. And then subsequent to that, the dean of St. Louis University invited me to come in for a visit, and I visited with the rest of the faculty there while she was not there because she was actually on a trip. And so, so I interviewed the whole rest of the library itself and everyone else, or they interviewed me without Eileen there, which didn't make really a lot of sense as I think about it now, but it worked for them because they eventually decided to hire me, and so I ended up going to St. Louis University for my first professional position after having finished all my degrees. And I was the associate law library director there. We had a rather small staff, but Eileen Searles, just very, very capable, and she spent a lot of time also mentoring me, and indeed more closely mentoring me than I had when I was at the University of Texas, insofar as once a week we would have a dinner together because each of the librarians on our staff were required to work one evening a week, and so it was convenient for me to have my meal with her while I was in downtown St. Louis. So that was very, very good, and I learned quite a lot there. And was there just a little under 2 years when the position opened up of being of a head law library job at University of Missouri, Kansas City, with the retirement of Eleanor Blue. And Eileen encouraged me. Well, actually what happened was they had gone through a number of people to interview and had not really found anyone to their satisfaction. So Eleanor was talking to Eileen and was telling her woes about not being able to find somebody to replace her, and Eileen suggested me. And so they called me in, and then they ended up hiring me. So then I was at the University of Texas, University of Missouri, Kansas City for 10 years. I stayed there while we moved into the new building there, and I helped build the staff there, helped do quite a lot of good things, brought both at St. Louis University and UMKC, they were some of the first to get Lexis outside of Ohio. Because the Missouri Bar got very interested in Lexis, and so Lexis was just starting up at that time. So both at St. Louis University and at the University of Missouri, Kansas City, I wrote memos to get administration to make sure that we were able to retain Lexis after the grants from the bar ran out. And in both places I was successful. I was especially pleased at St. Louis University being able to do that because St. Louis University had come out of bankruptcy just a couple years earlier, and so they were very careful about how they spent their money, and but the Jesuit fathers there realized that this was the coming wave, and so they bought the necessity for keeping Lexis on board. So I built up that a little bit. We were one of the first schools also to develop a computer lab for training both Lexis and Westlaw. Drake, I think, was first, and we were like second or third. Also was one of the first schools to build up a lab for teaching students how to use PCs. And the University of Missouri itself generally computerized its catalog in the early 1980s, and I was one of the ones helping, at least with putting some input with regard to that and having it done there at the University of Missouri in Kansas City. So there was quite a lot of things going on, but I do remember the reference desk. We had the terminal for the online catalog, the Lexis terminal, and then a PC. So the person had 3 different systems operating at the same desk there as a reference librarian. So it was, those were the old days when you didn't have it all combined. So it was pretty interesting. And then we moved, then from there in 1987, to be truthful, what happened was I was moving forward and thinking sort of visionarily, and the University of Missouri was just having financial issues. And this didn't seem to be going where I wanted to go. So as a result of that, I started looking around for other positions and interviewing at some. I had interviewed at other places before a little bit, but this really started in earnest in '86 or so. And then the other thing about that was I was probably not as I'll frankly say I was not as skilled at academic politics as many other law librarians in academia had been, and so academia was I guess some of its wonder that I had as a student and thinking such as that, and as you do recall, I also had realized how what a struggle it was to be a philosophy professor, and seeing how philosophy professors had trouble being working in academia. And so my wife said to me, Charlie, you ought to look at other positions in addition to academic positions. And she also suggested that I look at other places in addition to that. And it happened that a friend of mine, Mark Linneman, had gone from the University of Iowa to the University of Melbourne. And so I was more realistic about, maybe I should look into that. So I ended up in '87, I ended up with 3 offers. One was to be the state law librarian of New Mexico. One was to be ahead of a new computer clinic program, not in the library, but a separate computer clinic program at Monash University in Melbourne, or to be the director to San Diego County Public Law Library. And honestly, the one that had the most budget, the most base there, was the San Diego County Public Law Library. I could actually do more things there than anywhere else. And the other thing that was sort of interesting to me was that I would be working for a board of trustees. And so all of these people, there were 5 judges and a couple of attorneys, but all of these people had chosen to be on that board, which meant that they were seriously interested in the welfare of the library, as opposed to my having to fight for the library along with, in the same battles as for faculty salaries and for all the other kinds of things that had to go on when you were trying to deal with it in academia. So I saw that as potentially a positive as well. And so I went to San Diego County Public, or actually it's just called San Diego County Law Library at that time. So and that was as Jim Werner was retiring, and that was where I stayed for about 18 years, and then and in there I did pretty well. It was very well, actually, I thought, because we were able to do a lot of visionary things. We had a foundation there which didn't do very well for fundraising. It had been something set up 2 librarians prior to me under Leland Stanford had been a librarian there. But then that Leland Stanford is the nephew of the Leland Stanford from Stanford University. Anyway, he had set up the Law Library Justice Foundation, and that was primarily to bring in books and funds that were being given to the San Diego County Law Library when it moved into its new building in 1958, rather than having them go straight into the budget, the separate Law Library Trust Fund budget that we had with the county treasury. And that was primarily for the purposes of being able to continue with the contractual obligations of how they shared out the mortgage for the building and that. So, but it was to keep those gifts from being used in lieu of public finance. So we had this separate little arm there, which was very interesting. And then with that, of course, there were the financial difficulties that were beginning to evolve in 1988, 1990, that sort of thing. And so I told the board that if we had this foundation already, let's make use of it. Let's really get some real fundraising going with it. So I spent some time with Edgar Bellefontaine at the Social Law Library and became very much mentored by him, if you will, to be to really get into really good fundraising, and also took a lot of coursework. Started taking things on fundraising that were given by the Public Library Association and the California Library Association. Eventually, I went through the full week course that was taught by the Center for Philanthropy at the University of Indiana, and so did a number of things to really get on, become something of an expert on fundraising, and we built up the Law Library Justice Foundation into a relatively significant amount of something to add to the library's financial well-being. And with that, we also learned a lot about grantsmanship through public entities, and that myself and a couple of other county law librarians were instrumental in helping the State Library of California to recognize county law libraries as public libraries and therefore eligible for LSTA grants. And so we began doing some nice things there. The other thing I did was a lot of work with the other county law librarians on legislation, and became something of an expert in doing advocacy, legislative advocacy as well. So those were sort of outside the library activities, as you will. Whereas within the library, we also built, we had our own automated library system. This had been started with a small local consultant in San Diego under Jim Werner. And when I came on board, I had him move us from a CPM-based system to a PC-based system with a PC network. We went into NetWare, and we then moved it into it was not the Windows format, but it was the old format, but it had Windows in it, so you could have screens pop up with other screens and such as that. And it was a pretty good one. We were thinking actually of marketing it, and did market it to a law firm and to the Whittier Law School. But eventually, at one point there, the guy we had working with that didn't want to expand beyond himself, and we needed him to get more staffing if we were going to go into the Windows environment. And so we just suspended that operation and stayed with that and waited for other systems to catch up to its flexibility. It had MARC record compatibility, full serial records, full circulation system, which was very much set on our we had 4 libraries, so you could put in anywhere and get the information on all of them. And so we had a lot of stuff that was already built in. So then eventually we started through the process of doing an RFP and moved the library up to, we then chose Innovative Interfaces as really the one that really kept going with the same things we had, and so we became another innovative library. So that was all very interesting and good stuff. And then I stayed there until around 2005, and then I had a motivation at that point, I thought, to move on to other things, if you will. Part of it was the things to be done at San Diego County Public Law Library. Well, I guess one of the things I should talk about was we're always continuing to search for money because we're basically dependent on civil filing fees for our personnel and book budgets and our computer budget. The county government was supposed to supply us with a building and with a telecommunications stuff. It was always a fight to make sure that they did what they were supposed to do. But the civil filing fees were also simply not keeping pace with the inflation, especially, for instance, in law books. And so we needed to continue to find other sources of income. And so one of the things I was hoping to do was to join with the public libraries in creating a sales tax district. Yeah, so we could go take a sales tax measure before the people in San Diego County get a sales tax. It was through that process there we realized how, and in doing a number of surveys and that, we realized that essentially 50% of the population had never heard of the San Diego County Law Library and did not know that we were open to the public and that we were serving them, while at that time better than 50% of our users were members of the public. So we realized we still had a lot of marketing to do and other things such as that. And one of the areas we had problems with was in working with these. The public libraries were quite friendly to us because, as one of them said, you know, if you guys weren't around, we'd have to invent you, because we would have to have, because people come in asking for law materials anyway, and then we can refer them to you. And you're down by the courthouse, and we're not located in the right place, and all these other sorts of things. So there was, so these were, so the librarians were pleased with us, and we a lot of cooperative effort there. But the friends groups of the libraries, which were, of course, necessary for them for political advocacy, didn't know who we were at all. And so we decided, and this was actually a suggestion from my wife. I said, because one of the city councilmen said, you know, you ought to get a better name than law library. And my wife said, why don't you just say San Diego County Public Law Library and then put public in the name, and then everyone will know. And so I looked it up, and yes, indeed, we had the right to do that. My own board could do that. And all I had to do was then register it with the county. And so we did it, and we were the first county law library, or any kind of law library in the country that actually added public to its name. Immediately I found out how good that was, because my executive assistant was also the person who answered people who made calls to the general library number. And you know, half the calls she'd be passing to the circulation desk or the reference desk, or others she'd be passing off to various other places like that. But a lot of the calls came in, and the question was, are you open to the public? And now she started answering the phone, Public Law Library, and they would say, you just answered my question. So we realized that was quite a good thing to do, and so we went with that. Unfortunately, we still didn't have the oomph to get onto the tax measure, but unfortunately that tax measure never did get passed, so the public libraries were not able to get that funding, which they really needed. But we weren't anything that brought that ship down. It was just they weren't able to pull it off, but we weren't able to get into it. That was primarily because I had to convince 18 municipalities as well as the county government to get behind it. It just couldn't be done. But those were all great times, and so we learned a whole lot of stuff. And while I was there, we changed a lot of legislation in a very good way. Worked very closely with Charlie Dyer at the Sacramento County Law Library on legislation issues and that, and we had hired a couple of lobbyists through that period of time, and was very strong with that. That was some of the pleasing stuff. We were able to get a fair number of civil filing fee increases for the library while I was there, so that our budget was, it wasn't perfectly stable, but at least it wasn't being so fractious that things were bad. But over time we ended up with a little bit of attrition. And that was a little hard. And the other thing was that we really needed a new building, and I was working on trying to do a public-private project where we'd have a big parking lot parking garage and then the law library on top and then some offices on top of that, sort of thing like that, and trying to get that whole thing together. And it almost came to pass that that was going to pull off, but just prior to my board wisely said, let's go to some outside experts to get an opinion in addition to the parking garage people and the other people I had pulled together for this project, because we thought we were about a couple $1 million shy of being able to pull this off. And, you know, it was about a $40 million building, and so we were looking at that, and what turned out was that the state government had canceled out on some buildings that they were going to build, which would have consumed a lot of parking lot space nearby, and so there would be much tighter parking in downtown San Diego, so that was going to work. But they had canceled that. So these experts came in for us, and they looked at that, and they said, no, your distance figure is about $8 million. And we knew that our foundation was not capable of pulling in $8 million. I did have a big donor. The Hervey Foundation was a big donor that we had been able to recruit and get going with that. But the public-private project didn't go. So that was one of my, I wish that had happened. So where to go from there? And that was kind of done. I sort of done things, you know, got everything going. And so I looked at that and I said, well, there's other reasons I'd like to. I wanted to go on and do a lot of independent research and writing. And so I looked at it, and my wife said, you know, Charlie, if you're going to retire, 2005 would be the year to do it, because she said the housing bubble is going to burst. And right now we can get a good price on our house in San Diego and move anywhere in the country we want. But if you wait a little bit longer, it might be a lot harder to get out from under, or get out, and with any kind of a nice pad like we were able to get. So that's the way we went. So we did. So after that point, then I went on to being doing some consulting and doing a lot of independent research on that. And I think you have another question on that area, so I'll wait for that a little bit. But I did want to say there is a nice little bit of an end to the story with regard to the building in San Diego. Some many years later, they ended up completely refurbishing the downtown building that we already presently occupied, and a good deal of it was done through very, very significant financial efforts of both the Hervey Foundation and others who brought it in. So that's two librarians later, W. John Atkins and his crew, that had done an excellent job working with the very strong Law Library Justice Foundation to pull that off. So as I had seen all that happening and coming to pass, that was very, very good to hear that they've been able to pull that off. So that was pleasing. I felt pretty nice about being able to set that in motion so that they could get that job and complete that work.
Well, Charlie, it sounds like you had a very interesting career, and you had it in more settings and more types of libraries than many of us certainly did. Starting out in academics and then moving into the court library in San Diego. But you did retire at a reasonably early age, even by today's standards. You were about 58, as I recall. Mm-hmm. And then, since then, you've moved here to Bellingham, Washington, and you have become a consultant and an independent researcher. Could you talk a little bit about that a bit, and perhaps about your motivation for making this change in your life? I mean, you've sort of already kind of introduced us to it, but is there anything else you'd like to add on that?
Well, yes, there are. I made it almost sound like I was kind of looking for, getting tired of where I was going and looking for something else to do, and it wasn't quite like that. Perhaps the one thing that probably geared me up to thinking about retirement was the early retirement that Shirley David took. She retired at 55, and so that kind of put it in my brain, I guess, to work with that. The other thing was that during that whole period of time that I was there in San Diego, working with her and my wife and I and she and Shirley and Don, were very good, very close. Every time I'd go to Sacramento, which would be 2-3 times a year, we'd all go off doing wine tasting and doing other sorts of things like that. And oftentimes I stayed at her place. I was not the only law librarian who stayed at Shirley and Don's, but it was a good and regular thing for us. And they took us sailing, lots of other things like. So it was a loss when Shirley and Don picked up and moved to Hawaii. So, but it also just got me thinking. And the other thing that had been, and let me kind of start back. This is sort of a philosophical thing for me. I had ended up teaching legal research and writing, and the other course I taught at the University of Missouri, Kansas City early on was regulated industries. I wanted to teach jurisprudence, but jurisprudence was already in the hands of a couple of the older professors, and I couldn't, and you can only teach so many jurisprudence classes. But regulated industries, and they still had regulated industries back then in the late 70s, early 80s, was that they had social policy issues right up front in making those decisions. Lifeline rates for electricity, who gets what, how all the money works, this sort of thing like that. So it was all sorts of wonderful things that were there in that field there. That was one thing that kind of tied me for that. But the other was I really began to get very, very strongly interested in legal research and writing. And began to draw into it the whole notion of using rhetorical devices, learning how to do description, narration, comparison and contrast, those sorts of things such as that. And it became to me, as a philosophical interest, how there would seem to be this duality and matching of things. We have within law, you typically think of the sort of the usual way a brief argument would work out as being something of a deduction. You have your general rule, you would have the specific facts of your particular situation. You do some analysis as to how that, whether the facts said that you were within the class covered by that rule or not. Oftentimes inductively saying, okay, here's another case with this, here's another case, put them together, and there it is. And then you come out with a conclusion as to what the judge would probably say about your fact situation with regard to the law. So I was teaching this deduction and induction pattern there, and noticing that. And of course, in law, you oftentimes don't have so I was also teaching that along with doing research and referring to the fact that the index approach, which is sort of a factual approach, kind of melds in with thinking about an induction of as you're writing. And then the topic approach to opening your book using table of contents or headnotes, that sort of thing, would kind of set you up for a sort of general rule and a deductive approach there. And so I was giving my students a lot of this stuff. It also fit in with, as we began to teach database research and the principles of precision and recall. And a search that's more precise typically has more facts added into it. And then one that's more recall-oriented typically is more oriented toward concepts. Larger, broader concepts of legal rules. And so I was teaching these two balances as was going along there, trying to figure out what is the sense of how all of this comes together, and thinking back to my old days of studying phenomenology and how we come to know things. And one of the things I realized is that as a lot of other people were realizing at the time, was that legal positivism, which was sort of the name of the game of how we thought about law in court, didn't really do the rule. It was legal realism prior to that, prior to the Second World War, and of course subsequent to that, the continental philosophies would influence a lot of work. So you had things developing like critical legal studies, other things such as that. And there were others who were also looking at these issues also, such as law and economics and other patterns. They were trying to get the underlying seed of how do you make real sense of the law, and how does legal information and knowledge come into us so that we make reasonable decisions. So all of this stuff was melding through me and everything like that. And then I ended up going over to the San Diego County Public Law Library. And while there, of course, with all that other stuff that was going on, I just sort of suspended that effort for a little bit. But the other thing that happened was that I began also to see the issues that self-represented litigants, per litigants as they were called in California, pro se litigants as they're typically called elsewhere, that self-represented litigants had with learning legal discourse, and began to do some serious thinking of what is it that's going on there, and began to become interested in writings of a number of other people. As Richard Posner turned into a neo-pragmatist, that really I started reading Richard Rorty, and as Austin, I want to say Slater, a couple of other people had the culture and law movement, some of these other kinds of things. I was looking at those a whole lot, sorts of things. So by the time 2005 rolled around, I was into this whole bubble of thinking there needs to be more work done with regard to that. And so I had this independent research mode in my mind, if you will. And so I let people know about that. Who were friends of mine, close friends of mine, within the profession. One of them, fortunately, was Pam Gregory, at that time just about retiring, county law librarian for Prince George's County in Maryland. And she was a good friend or knew Richard Zorza, who was just at that point developing the self-represented litigation network, and told him about me and my interest in that research line there. And he had already recruited Judy Meadows on board for the network, this new network he was developing. Called me up and asked me if I'd be interested. So we talked through the whole thing. We realized my place in that organization would be on the research working group with my interest, developing that in the lines that I did. Then as it occurred, as strange things would, a little bit later he said, why don't you also join the information marketing and outreach working group, which was sort of their top working group, which was the one that built their judicial conferences and density and other things like that, for the purpose of helping us reach out to law librarians. And Judy also came on board like that. And so we ended up with this thing. And Richard had an idea of actually having subgroups for that. So we ended up developing a law librarian subgroup, and I ended up being the person who was in charge of that. And so that went along for a while, and for quite a while. I mean, it's still going on. That was the call. I was on a call just before this thing here, and the call I just had was the law librarians group. The thing that I could see was that if law librarians in the public law library sphere were going to remain relevant, they had to come on board with this whole movement toward access to justice and serving self-represented litigants. That you could not have a county law library be there as primarily a resource for local bar members, but the local bar members were all on Lexis and Westlaw, or any of the other even more recent priced services, and were barely dropping into the law library anymore. You had to be there serving the public. It made not only the public was there and needed the service, but also the political sense of if you're going to go out and tell county governments or state governments or whomever else, however your financing would occur, that you had to be there to serve the public. And the typical pattern was, for instance, in California, and it's also repeated here in Washington State, that better than 50% of the people of the cases were divorce cases, neither side is represented by an attorney. And in Washington State, 80% of the cases, at least one party is not represented by an attorney. these are a lot of people in that one particular area. And of course, there's lots of other areas, landlord-tenant, small litigation, small commercial litigation stuff, where you often have a lot of people who don't have access to attorneys. And so that needed to be something that needed to be broadened. So part of my gambit there was not only that law librarians should have input into the self-represented litigation network and the whole access to justice movement, but also that their recognition of law librarians and law libraries and their purpose in the whole structure, the whole system of serving self-represented litigants was important as well as a part of how that should happen. And so it was a year or two later after that we got it going with that. This is probably about 2008 or something like that. So 2007, we made a concerted effort to make the Self-Represented Litigation Network be one of those organizations that AALL partners with and has representatives to. And for a while there, AALL also made small grant contributions to the network. So now when you look at the Self-Represented Litigation Network organization website, the American Association of Law Libraries is listed as one of the 15, 16 national organizations which are supportive of the network. So that was one of the areas that was going on with that. While all of this is going on, my independent work on this, my own research and studies, led me to, we go down to the University of Washington, the Gallagher Law Library, and look at various works on jurisprudence and legal discourse and that, and got to reading various ones, many of whom were relatively unsatisfying. They weren't getting past that little problem of how do you relate, how the knowledge comes in, the knowledge really sinks into us to build into legal discourse. And but I came across some very effective books that gave me some real sense of things. Especially informative were the writings of John Conley and William O'Barr, Susan Mary, a number of others who were discourse analysis people who also were writing in the area of law. And they got me to see that regular people don't think like lawyers. When you talk about thinking like a lawyer when you go to law school, there is a big difference. There is a significant difference. Most people do not think in terms of deductive reasoning. That's not how they think. They think in terms of relationships. So a guy comes to you and says, to an attorney and says, I want you to help me. I got this case against my neighbor. Their dog barks all night long and I can't get any sleep. And it's just horrible. And so you're like, okay, we'll deal with that. It's dog law. He says, oh, and by the way, his tree hangs over my fence and I can't, and it shades over my garden and I can't grow any vegetables there. Okay, that's another case. And then he lists about 4 or 5 different things, and the attorney tells him you've got different cases here. And he says, can we just sue him? You know, like all at once, because his problem is that his neighbor is considerably inconsiderate and they can't get any bargaining done. So that's, in his mind, the problem is a relationship problem, not a legal problem. He doesn't break it up into the legal rules that are problems there. And so that's the sort of things we were finding, is that people think in very different ways than lawyers think. And so that I was finding. So trying to go further from there, I then came across the writings of Professor Stephen Winter, who is an advocate of, I think he's at Wayne State now. So I haven't talked to him in a few years. So anyway, Stephen Winter had written a book called A Clearing in the Forest, Law, Life, and Mind. And in it, it was majorly introduced the concept of using cognitive linguistics as a basis for thinking about how law reasoning actually happens, as opposed to thinking in terms of some of the more regular kinds of systems, such as legal realism, critical legal studies, or law and economics, and others. And so I ended up writing an article about all of that, partly with my experiences from San Diego, and partly with my experiences with reading that. And the title of the article was "The Queen of Chula Vista," and a call for trying to remember the whole title, but anyways, cognitive linguistics should be something that legal researchers and law librarians ought to be looking at. And so I became much more interested in that. Subsequent to that, I got a AALL grant and did a lot of research in cognitive linguistics, and put together a bibliographic essay, which is available on my website, and some other things, and have continued to go with that. Became the proponent of using, and let me give a short description of cognitive linguistics, real short. Here's the difference here. Linguistics became more than just description of languages and families of languages back in the 50s with Noam Chomsky's development of generative grammar. He began to see some of the underlying roots and connections of how that worked. But to Chomsky and those people who follow in Chomsky, and there's a considerable portion of academic departments where Chomsky and generative grammar are the primary theoretical framework. But there are a lot of others who were disciples of Chomsky who in the 80s alternated from that or turned against it, based on a lot of the work from cognitive psychology and neuroscience. And they began to say that the primary basis for language is not grammar, but is meaning. So it's the semantics component of it that is much more primary. And with that, they began to develop, and this is a good sense to me, is how do you develop concepts out of the phenomenal world that you see? So I'm back to looking at a phenomenological view of things, but from their point of view. And so with the writings of George Lakoff, Mark Johnson, Ronald Langecker, who wrote Cognitive Grammar, talking about even grammar has developed out of our understanding of our cognitive perceptions. The conceptual metaphor theory, and the use of prototype and radial concepts, and conceptual blending, all these wonderful, wonderful ways of finding out how we develop our language through our necessity of being able to convey meaning. And of course, that's a central problem for self-represented litigants. Richard Zorza has a book called The Self-Help Friendly Court, and he lists 7 barriers. 5 of the barriers to them are information barriers. Just knowing what's going on, knowing what your remedies are, knowing what your procedure is. But a large amount of this is information barriers, and you realize that the barriers are in part because lawyers trained in discourse think with considerably different conceptual viewpoints than self-represented litigants do. So now, what am I doing? I've been for a couple of years the program manager for the Washington State Access to Justice Board's Pro Se project, where we are developing plain language court forms in family law. And on top of using the plain language work, the very good plain language work that comes from Transcend, and the very good work we have from our reviewing groups here, and I do a lot of mostly managing, grant writing and managing, and that sort of thing. But one of the things that I add into the process there is to get a lot of the people who are working with us to think in terms of how the simple words we're trying to use, why are they simple as opposed to hard? They're simple because they're cognitively more apparent to people. And that's the sort of stuff that I really get onto now. For instance, one of the examples I give is the word loan and the word lien, L-I-E-N, same length. So your Microsoft Word plain language processor would hardly notice the difference between the two. But loan is something that any child learns relatively readily. Let your brother borrow that for a while, kind of thing like this. Lien involves secured transaction on some piece of property and all the sort of cultural aspects to it and business aspects that have to be learned, and it's a much more complicated word. So there was a running argument on the Plain Language Association list where these guys trying to figure out how to reword a divorce form which said essentially you can't put a lien on your house while you're going through the divorce. They had to figure out what word to use. They finally came up with the word barrier, which was perfect because that makes sense. A barrier is in the to moving someplace, the whole business of what they call in cognitive linguistics the source, path, goal, steps to the courthouse, life is a journey, and it's all this whole pattern of using physical steps to represent conceptual movement, movement from one place to another place. And so so that barrier is a cultural metaphor, but it's a universal cultural metaphor because every culture has it. So you can use barrier, and it will make sense to the Mixtec Indian whose first language is not even Spanish. So that's the second language, and the third language is English. And he's up here trying to figure out, oh, okay, that's what that little phrase is about. Is you have to be able to not place any barriers to the sale of a house. And so that's the kind of stuff that is it's exciting to me now. And it's keeps me pushing, keeps me moving. So that's kind of where I went there.
Well, Charlie, you have certainly served the profession in a whole variety of ways, most of which have not been mentioned, but I will mention a few of them. You have served for a while as the editor of the Law Library Journal. You've been elected to office in several of the boards and chapters of ALL. You've also done a lot with the State Court and Law and County Law Library and Special Interest Section. Not long ago you were recognized for a lot of the service as a recipient of ALL's highest honor, the Marion Gould Gallagher Distinguished Service Award, and you've also been inducted into ALL's Hall of Fame. These are all honors that are only earned by a handful of our colleagues, and you've obviously done a lot to achieve them. I want to thank you, Charles Dyer, for allowing us to visit with you today and for taking these few moments to share so much about yourself and about our profession. Before closing, however, is there anything you would like to add as we conclude this interview?
Yeah, there is. You actually started talking about the Gallagher Award and those things there, and of course I received the Gallagher Award before I went off on this whole research effort into cognitive linguistics and that, and was very grateful having done so. I'm very honored to be in the company of the others who've won the Gallagher, and Gallagher herself, of course, Marion Gallagher. It was a great pleasure to have known her, and I didn't know her closely, not like you, but certainly close enough to greatly appreciate her, the people she mentored, and how much she's done for this profession. But I kind of contended that the reason I won that award was not just the variety of services that I had done in WLL, but occasionally because there are a couple of things that I did that I was quite proud of. One of them was when WLL was developing its strategic plan in the late 80s, early 90s. They asked everybody, they said, well, we're starting on writing this plan. Here's this draft. If anybody has any comments, make big something. So, and it was, I'm sorry, I've lost the name of who it was. It was the very capable leader of that work. Anyway, so I wrote a letter. And essentially what I wrote the letter saying was that the law libraries, it's the American Association of Law Libraries, not the American Association of Law Librarians. And in that regard, we have to think broader than just ourselves. It's not just about law librarian job security or just about law librarian status within the various roles that law librarians play in academia or county law libraries or in law firms and that. But it's more than just that. We should be people who are seriously interested in the open and free access to legal information, that we should be lobbying for support of law libraries themselves and for support of those sorts of institutions which enable legal information to be pushed out there. To my great surprise, two things. One was, evidently I was the only letter written. And the second one was that the committee listened to it very greatly and added some things into the strategic plan, which I think goes on to this day. And I'm not saying that the WALL had never, I mean, because obviously we had things like the contemporary social problems, SIS, and a number of other things have been long before I made that statement. But the real point was that it got into the strategic plan and has remained in the strategic plan, and through others, serious funding for legislative advocacy, government research, relations committee, and the whole Washington office and that and everything. All that kind of stuff like that, I think, was doubly supported by the fact that that the purpose for the association is broader than that, and I was kind of pleased to remind them of that, I guess, if you might say. And then secondarily, along that same line, back when I was the head of the State Court and County Law Libraries, SIS, the chair, most of the advocacy that had been going on at that time by WALL was on behalf of dealing with federal legislation. We had certainly copyright and the myriad of other things that go along that seem to want to restrict our ability to get information. And those were all good programs, but I then pushed, and the Government Relations Committee bought it, and it then went on to become part of the whole advocacy system, that WALL also had a responsibility for dealing with state legislation and in particular state funding issues of public law libraries as well as other institutions, but in public law libraries, and that became a part of that effort there too. And so I guess in part I'm just sort of pleased about being noisy. One of the things I do remember saying in my Gallagher acceptance speech was, working in this profession and all the wonderful people in it has certainly been great for me. And people, when you say something decent and purposeful, they go and do it, or they listen to you, or they come back with wise statements as well. And so we are a community. I mean, I remember having taken trustees from my county law library to WALL meetings, and they're like amazed that, the librarians all go to the education programs. They're not off playing golf. They're all learning stuff. They're all making contributions at these programs. And it is serious work that goes on at WALL conventions and other things. And I think that that's part of what is good. And yet, at the same time, we're all very, very convivial and get along well and open to each other and open-minded. And so I would have to say that's it has been, as an occupation, a really good one. And the fact that I was in academia, the fact that I was in the county law library administration, and my various routes and getting into all these various fields like that. It's always been very good to be in this group of extremely supportive, broad-minded, liberal people who do so well and keep it going. And I'll actually kind of close with the fact that Richard Zorza has observed more than once that the law librarians within the Self-Represented Litigation Network are such a treasure because you give them a task and it gets done. They make the phone call, the conference calls as best as they can, as often as they can, and they're always making a contribution. And so, although our numbers are small within the network, our influence is quite well felt, and I think that generally that's true in lots of other ways as well. So that's probably my closing statement.
Again, Charlie, thank you for taking your time this morning and for talking with us. And